Mr Chairman, can I start by apologising, first of all, for the late notice of this application?
It shouldn't have happened as late as this, should it?
It should not have, no, and I can only apologise for that. If we could have made this application any sooner, we would have done. I entirely appreciate the position that this puts not only you, sir, in, but also your entire legal team, and of course the position that it puts the other legal teams in. And the decision to make the application at such short notice was not one that was taken lightly, and has arisen from what we consider to be an urgent situation. It's certainly not something I would intend to repeat again, and I would just like to unreservedly apologise for that, sir.
All right, thank you. Just help me with this, though. This application is directly made in relation to Mrs. Wahabi's evidence.
It is, yes.
But it's of equal relevance to the evidence of Mr. Gomez, isn't it?
It may well be equally relevant to the evidence of Mr. Gomez. Right. That rather depends, sir, on when, during the criminal trial that I'll come to address you about, happens, and when Mr. Gomez's evidence happens within that criminal trial. Yep. Because the nub of the issue is evidence in the public inquiry being broadcast before either of those individuals give evidence in the criminal trial. That's the nub of the application. Mm-hmm. If the criminal trial runs as is planned, which is to start on Monday, it may well be that Mr. Gomez's evidence is heard in that trial before he's due to come to the public inquiry. I don't want to cause Mr. Gomez any alarm, because I understand he hasn't been told when he's going to be giving evidence in the criminal trial yet either. So I don't want to set hairs running about that. But it's certainly our understanding that the intention is for the witnesses who are giving evidence in these proceedings to give their evidence as early as possible during the criminal trial.
All right. Can I just ask you, who are you instructed by
I'm instructed by the Metropolitan Police Service.
Is this not a matter for the Crown Prosecution Service?
Well, sir, on a strict reading of the matter, perhaps. Well, the reality is, sir, that we are a partner agency of the Crown Prosecution Service.
Well, maybe you are, but you see, the application, so far as I've been able to consider it, raises a number of questions, at least in my mind, about the nature of the evidence that either of these two witnesses may give here, their relevance to the criminal proceedings, the nature of the concerns which someone has about the criminal proceedings.
Yes.
And it seems to me that this is something which the CPS ought to be shouldering. And I'm not at all persuaded that it's for the police to make an application of this kind.
Well, sir, the reason why I make an application on behalf of the Metropolitan Police Service is we're certainly making it at the request of the Crown Prosecution
to put it bluntly,
Service.
Why does it matter to the police? It's a matter for the prosecution.
Well, sir, because the police have a profound interest in the administration of justice as well, and ensuring that we do all that we can to try and safeguard the criminal proceedings, and to make sure that where matters come to our attention that potentially prejudice those criminal proceedings, that we do what is appropriate and what we can in order to raise those concerns. Of course, we have status as a CP and the CPS don't.
Yes, but that, again, isn't relevant, is it, to course of conduct which is said to be potential, at least, to undermine the administration of justice.
So I can entirely appreciate
and I understand
that.
why you're here, and I'm grateful for your assistance, but I really think this is something which the CPS ought to be putting forward on their own behalf, as I see it at the moment, at least.
Well, so can I also add a different logistical dimension to that, which is that the application is being made at extremely short order. The risk of seeking to make this for the CPS to make this application would have potentially meant a further delay in that happening. And given that the Metropolitan Police Service are here, so you're due to hear from this witness at 2:00, we were mindful not to encourage any further delay in this particular matter being determined. So we find ourselves in the position where we are here and able to make representations, sir, insofar as you're willing to hear from me about it. But I entirely appreciate the position about the CPS being the prosecuting authority, but the Metropolitan Police Service do have an interest in that as well, for the reasons I've outlined.
All right, thank you.
So if it's of any assistance whatsoever, I would be willing to characterise the application as a joint application.
You mean you're now instructed by the CPS as well?
Well, sir, I'm instructed
No,
by
you're not this clerk. You're instructed by the MPS.
I am.
Yeah, and for better or worse, that's the basis on which the application is being
It
made.
is, sir. It's joint, not in terms of instructions, but certainly the Metropolitan Police fully support the application.
All right. Well, shall we get to the nub of it?
So yes, so the nub of it is that, so I apply for a restriction order in respect of Ms Wahhabi's evidence to the public inquiry. I seek a restriction on the publication and broadcast of her evidence until the conclusion of a criminal trial that is taking place next Monday. The criminal trial is due to run for an estimated 4 to 5 days, and therefore I ask for a restriction simply until the conclusion of those proceedings. If I may set out some background about those particular proceedings. The trial is a fraud trial relating to an allegation of fraud by misrepresentation of an individual who is said to have falsely and fraudulently claimed to have been a resident at flat 182 in Grenfell Tower.
I think I've seen the indictment somewhere, yes.
Yes. So
Yes, go on.
I'm reluctant to reveal any particular details about that individual because I'm not sure it's necessary in these proceedings.
Well, the long and
or
short
this
of it is that
application.
he's being prosecuted for fraudulently representing that he was resident in flat 182.
Yes.
Is that right?
Yes, that's
And
right, sir.
on that basis, obtaining very substantial benefits in cash and kind.
Absolutely, sir, yes.
Right.
And it's one of the number of fraud cases that have received widespread press attention, quite rightly, following on from, of course, the terrible events of June last year. But this is another fraud trial within those investigations. And, of course, this relates to Ms Wahhabi. And Ms Wahhabi has provided evidence to the investigation, to the fraud investigation, and indeed is intended to be called as a witness at that trial. The concern that arises from the CPS is that any publication of her evidence may give rise to arguments about the defendant in those proceedings being prejudiced in advance of that trial. And that is really the issue, is her evidence being broadcast or reported on before the outcome of that trial. The risk arises because of the potential for any such argument being made by that defendant that might derail the listing for that trial. There are statutory time limits that are imposed about an individual's custody, and if this trial doesn't go ahead, the time that the authorities have to detain this particular defendant will run out, and he will need to be released at the end of December. There is considerable concern that therefore jeopardising the trial window will potentially give rise to the frustration of these proceedings, because there is a real concern that if the matter were put off and if this individual had to be released, an application for bail would be made. If this individual were allowed to be at liberty pending any criminal trial taking place, there is a serious concern that he would abscond, and therefore the entire process would be frustrated. This isn't an application about the Metropolitan Police Service suggesting, from our perspective, that there is an inherent prejudice in Ms Wahhabi's evidence being reported because of the different character of the evidence to the inquiry versus the character of the evidence in the criminal proceedings. The problem is that there could be arguments made that could jeopardise the listing, and that's really the fundamental problem. And given that the restriction sought is for a very limited amount of time, we would ask for it as I've said, until Monday the 12th of November, just to allow for late running of proceedings on Friday, or perhaps jury deliberations tipping over into the Monday. If, of course, matters outside of my control take over, and for any other reason the listing is jeopardised, then we would, of course, need to consider our position about any length of time for any reporting restrictions. But in essence, that is why we make the application.
Well, this is something I'm finding a little difficult to understand. In the ordinary way, one would expect an application of this sort to be based on the premise that the witness in question might say something in the course of the inquiry that, if reported, might influence the jury. That's not, I think, the basis upon which you put this.
No, it's a slightly different basis.
Does that mean whatever she says, in the sense the fact of giving evidence is itself a problem?
Yes, sir, to put shortly.
Why should that be so?
Because an argument could be made that the widespread publication and reporting of Ms Wahhabi's evidence may well influence a jury.
In what way?
To the extent that it would prejudice the defendant, because if jurors were to have considered Ms Wahhabi's evidence and drawn any conclusions about her, or for example any particular positive feelings towards Ms Wahhabi as a consequence of viewing her evidence, the defendant may say that he can't possibly have a fair trial when the jury have already seen this individual giving their evidence live at the public inquiry about matters that are particularly emotive and distressing.
All right. And what sort of application are you worried about on the part of the defendant?
I appreciate, sir, that
he'd have to apply to stay the indictment, wouldn't he?
He would.
Well, that's a notoriously difficult application to succeed on, isn't it?
It is, and I can't possibly make any positive submissions about whether such an application would or wouldn't succeed. The issue is, in my submission, preventing that opportunity in the first place, when the way to prevent it and to secure, to ring-fence that evidence is simply to publish the evidence from the inquiry a week later.
Have you given any consideration to Section 4.2 of the Contempt of Court Act? Not because I'm suggesting it's perhaps directly applicable, but it does seem to me that the principles underlying it and the case law based on it are opposite to the inquiry.
Well, sir, I would say that you are entitled to rely on Section 4.2 of the Contempt of Court Act. The primary legislation, of course, that is the guiding principle is Section 19 of the Inquiries Act.
Well, that's what gives me my power to
Yes.
restrict reporting.
Yes.
But isn't the problem one of balancing freedom of speech against the risk to the administration of justice?
Of course.
And so the tests that have been applied in relation to Section 4.2, well, contained in Section 4.2, would seem to me at least to be potentially relevant to the exercise that I'm being asked to undertake.
Well, no, sir, I'm seeking for you, sir, to make that balance of the administration of justice versus freedom of speech. I'm effectively asking for the right to freedom of speech and for these matters to be publicised and reported on simply to take place after Ms Wahhabi's given evidence in the criminal trial.
Right.
It isn't a wholesale restriction forever, it's on a very limited basis.
Well, Ms Clark, I'm very concerned about this application, and I think it requires more careful argument and deliberation than we've really got time to undertake at this moment. I mean, in one sense, I'm afraid you're going to succeed in your design because it's not now going to be really feasible to take Mrs Wahhabi's evidence this afternoon.
Well, sir, can I
But
say...
there is still Mr Gomez coming along next week,
Yes.
and I think the same principles are going to apply in relation to him, aren't they?
That they may well do, but it will depend, as I say, on the progress of the trial. There is, of course, the possibility, at the moment the defendant in that trial has pleaded not guilty. If the defendant were to plead guilty, that would add a slightly different dimension to
Well,
matters.
it's a wholly different dimension.
Sorry, sir.
A wholly different
Yes,
dimension.
exactly. So there, again, there are unpredictable matters that I can't responsibly make submissions about. Can I just say on the issue of frustrating this afternoon's proceedings, it was absolutely not our intention to do that, and I want to apologise if that causes Ms Wahhabi any distress, because it certainly was not our intention to prevent her from giving her evidence this afternoon.
Yeah. Well, I think others in the room, I'm thinking mainly, principally, of course, of the legal representatives, the core participants, ought to be better informed about this application. And what I'm minded to do, and I also think, if I may say so, that I think that the press ought to have an opportunity to be heard, if they wish, on it at some length. It's a bit difficult to expect the representative from the Press Association, who may not have too much familiarity with these sorts of legal proceedings, to argue the press's interest on the hoof like this. What I'm minded to do is to say that we'll adjourn this application to be heard on Friday. I'm waiting. There's a question mark in my voice, inviting people to stand up and object to Friday, because I know it's a sacrosanct. Yeah, someone has.
So can I just raise one thing
Yeah.
before you finalise your decision as to whether you're going to hear this application? And it may well be of assistance to you and indeed the applicant making this application. What is surprising is that there is bearing in mind what's been asked for is a restriction order, and that is dealt with in section 19 of the Inquiries Act. It's somewhat surprising that this application has been made with no reference to section 19 and whether or not the application actually falls within appropriately section 19. The reason why I stand to my feet, I'm neutral on this because it doesn't affect my client, but with assistance to do so, the fundamental principle is firstly set out in section 18, which gives a presumption that these hearings should be heard in public and the public should have access. And the way, sir, you have been allowing the public to have access is through the streaming and so forth. Mm-hmm. Subject to an application for a restriction order under section 19. And the criteria under section 19 is fairly stringent.
Well, Mr. Thomas, I can assure you that I've been looking at both sections 18 and section 19. Section 19, as you will know yourself, is worded in ways that might admit of different interpretations. And I'm not prepared to say here and now that this does not come within section 19, but it's a point which is perfectly right to consider, and I hope Ms. Clark has taken it on board. I expect she has.
So the point I make, so that I'm not misunderstood, is so far the application has not been phrased with any reference to section 19.
Well, that's not quite right. You haven't seen the written note that I've got, have you? When you get it, because I'm going to direct that you should get it, you'll see that there is reliance placed on section 19. But I think if this application is going to be pursued, notwithstanding the fact that we're now not going to hear evidence from Mrs. Wahhabi this afternoon, it's got to be pursued properly. And my present view is it ought to be pursued by the CPS in their own right, not by the Metropolitan Police Service. Yes, Mr. Mansour.
Yes, I'm obliged. I wonder if I might, on behalf of Ms. Wahhabi, she's sitting right here.
Yeah, I'm sorry if she's been so inconvenienced, and I think it's
I'm very
unsatisfactory
about her welfare as a witness, because there are two sets of proceedings, this one and the other one.
Yeah.
We haven't been told whether it's a fixture. I was told informally it's a fixture. It is a fixture for Monday. Mm-hmm. I'm wondering if we might be given a little time now, because obviously one way round, having a hearing on Friday when she's supposed to be giving evidence on Monday, may be prolix, to say the least of it. It may be possible to resolve this afternoon for example, and I haven't discussed it with anyone, if she's due to give evidence on Monday, she goes and gives evidence on Monday and not here until after she's given evidence.
That may well be the case, and I see the force of that, and this is why I said that I thought Miss Clark had achieved her object by getting this application on rather late, so that we can't hear Mrs. Wahhabi now. But
there is another point here, which is, and I don't wish to necessarily espouse the possibility that it's been done on purpose, but nothing has been said in this application to indicate why today. What's the urgency today, other than somebody's woken up to maybe custody time limits?
Yeah.
It could have been done 2 weeks, 3 weeks, 4 weeks ago, because her evidence has been known in both, and it's really very unfortunate. And maybe you have something to say to the Metropolitan Police or whoever else about why it's come on now, but we are dealing with a situation where I would ask for some consideration for the witness.
You don't need to persuade me that it's deeply unsatisfactory.
Yeah.
It sort of first I knew of this was after the close of play yesterday afternoon. And I do think that, as I said already, I think this is a matter that the Crown Prosecution Service should come along and deal with in its own capacity.
Yeah.
And I would expect, if the application is pursued, as it may be because of the position of Mr. Gomez,
Well, that's true.
that I shall want to be helped on things like custody time limits, what the opportunities are for extending custody time limits, what are the prospects for the trial, a number of things of that kind, not excluding some of the points I've already raised about the Balancing Act and so on, and I think the press ought to be heard as well. And I'll hear other CP representatives if they want to be heard on it.
Can I just stand briefly, particularly because I act for other members of this extended family.
Yes, I know.
And having not had notice of the application, they came up to me before they went out and said, well, we've been seen by police liaison officers and we know what this is about because the person's being tried for fraud, which rather takes us to where we should go right now, because respectfully, if you are thinking of adjourning this, I haven't heard anything now that takes this beyond, with respect, the bog standard situation where you make the application in open court and the judge holds the ring until it's ultimately determined by saying, I will make a reporting order on the application itself. But there seems no reason why the people out there shouldn't know what is, in its outline, a standard application. Before I sit down, I can't stop myself from saying that on this side and over there are barristers that have never got anywhere near getting a stay or an adjourned trial on what has been very eloquently outlined. I wish the police came all the time and supported us in these kind of applications, but they don't. So, as a multiple loser in this area, particularly for terrorist trials, it might be said in all seriousness, we understand that Mr. Gomez and Ms. Wahhabi will talk about Flat 182. That's what has brought you here late. But what's the difference with Roy Smith this morning or Nadia Jafari last week? That's there. That's the fraud trial next week. It's not the same. So, so if you're minded to adjourn this, all I would say is that what needs to happen very quickly is that we are free, one way or another, perhaps for you to explain exactly what this is about and consider an interim reporting restriction so that everyone out there is included in the current debate. I would make a plea not for it to be on Friday because there is so much work that goes on Friday, as you know. And so
the trouble is finding a date when we can do it without interfering with a very tight timetable.
I do that, and one is obviously concerned about both the witnesses who are willing and able to give evidence as soon as possible. So that's all I wanted to add.
Yeah, all right, thank you. Well, it's obvious that you don't think I overestimated the prospects of succeeding on any application to.
Well, I stand
discharge the indictment
of very experienced losers where we have far more prejudice put before the courts, and we've lost these cases in the European Court of Human Rights as well.
Yeah.
So,
no, it's all right, Mr. Freeman. Don't worry.
It's not custody time limits. It's about due diligence of the prosecuting authority. And not about some prejudice that came out beyond their control. So. It wouldn't for a moment, in my respectful submission, even if there was an application to adjourn the trial, to the trial judge in the Crown Court next week get anywhere on custody time limits. But that's my tuppence on it.
Right. All right. Well, thank you. Yes, Mr. Teaton. Come on then.
My bite of the cherry in relation to the basic law, it's an exceptional jurisdiction to stay, very rarely applied.
Yeah.
In terms of the question of custody time limits, what we've heard today would actually be evidence that would not support an application to extend. This is actually a demonstration of failure of due diligence and what we have heard in the way the CPS have not acted. So that's that for the moment. The more direct problem that we have is on behalf of Mr. Gomez. What we are currently experiencing is going to be the potential for putting it over to Friday, which will have it, certainly for him and his family, a knock-on effect on the question of will he be giving evidence on the Monday, will he also be giving evidence on the Tuesday, and so on. What we respectfully invite you to do today, sir, is this. See what we can do today in relation to this application. The first step for that is for us to see the written application.
Yeah.
And then we can return back and make some rather more sensible submissions as to the further progress of this application once we have sight of it. It may be that we can persuade you, sir, to in fact deal with it today and get rid of it. If
Well,
so,
I think there's more to this than I ought to deal with, if possible, just on the hoof. Because it does raise, in my view at least, some quite important questions in relation to the balance between open justice and prejudicing current proceedings. And I'm concerned about the position of the press as well, because they're the people who are as affected as anyone on behalf of the public. So I'm sorry,
maybe
Mr. Steen.
right, we would ask, though, sight of the application being the starting point,
Yes.
then the possibility of making further representations
Yes.
today before we all depart. So at least we can take stock as to what we've
Well,
done so far.
what I'm going to say is I'm going to adjourn this application. I'm going to treat Miss Clark as appearing on behalf of the CPS by as a sort of deputy. I don't know quite how we put it.
Agent. Proxy.
Well,
Yes.
all right. I already said that I think the CPS ought to make this application in their own right. It ought to be served on all the legal representatives for the witnesses and the other BSR core participants. And I will adjourn it on that basis and continue the hearing on Friday. I'm sorry about that, but I think it's the only sensible thing to do without really driving a coach and horses through the remainder of the timetable. At 10 o'clock, unless other arrangements have been made of a kind that means it's not pursued. And that's possible.
So would you allow this possibility that we be provided copies of the application as soon as possible? In other words,
I thought I'd indicated that.
this afternoon.
Yeah,
And then, if sir, you are available, if there are representations that we believe can properly be made today, that we could return to it this afternoon.
Well, let's see how we go. I think certainly as a first step, you must have copies of I think you'll need the indictment and the written application. Is there anything else you think you might need that I've got?
Case summary may be of assistance. One of the matters
I
that
don't
is-
have that.
I don't personally have that either, sir.
No. Right, well, Miss Clark, you've got that, have you? You can serve all this material.
Yes,
It's not very bulky.
It's not.
Straight away, as soon as possible.
Thank you.
And we'll return to this on Friday at 10 o'clock. And at that stage, either you will appear on behalf of the CPS or someone else will appear on behalf of the CPS in your place, and be prepared to deal with all the information we may need in relation to the trial and other matters relating to this defendant.
Certainly.
All right?
Thank you, sir.
So in terms of the interim position, would you feel that you're in a position today to tell the people here what the application is about, but make an interim order pending its resolution, hopefully on Friday?
An interim order of what kind?
Well, the fact is, we've been in closed session here. That's not a situation that we would want to maintain unless absolutely necessary. And therefore, what I'm asking is that you tell the members of the public when they return effectively what the application is about. There's nothing that's been said here that in my respectful submission can't be said in public, but that you make a reporting order about it. So it's not reported beyond open court. And I say that because I've never been in a situation in a criminal trial court where an application like this has been made, where it hasn't been made in open court,
Yeah.
but that there's been an order to hold the ring. And I think probably all my learned friends would agree, A, that that's the norm, but B, no. Well, Mr. Mansell may want to say. Whether it's the norm or not, that's my application, that effectively you allow this application and what's just going on this afternoon to be made public, and you can summarise the position when it comes in. We can be in a position to explain to any client that asks what it's about, that you make a reporting order, an interim one that will then be reviewed. So that is my application arising out of what's going on this afternoon.
All right. Do you want to say anything about that, Ms. Clark?
Well, so I think it's a matter for you to deal with whether it would be an interim reporting restriction or whether it's just a reporting restriction actually for the time period I've requested. I'm not sure if that's just semantics. But I would say
there is, I mean, in a sense, your application doesn't have any, your substantive application doesn't have any content because Mrs. Wahhabi is not going to give her evidence this afternoon. She's not going to give it before Friday because of our existing timetable.
Yes.
When the application resumes on Friday, we'll see where it takes us.
Yes.
Now, the only question is whether I maintain a reporting restriction on the proceedings on your application so far.
Yes.
And I think what Mr. Friedman is suggesting is that I should at least make an open order that this part of our proceedings not be reported, and tell people that it's because an application was made that in relation to certain evidence on the basis that it might interfere with proceedings elsewhere. Now, you can object to that?
Yes.
Just a minute, Mr. Mansfield, I'll come to you in a minute.
Sorry, so I'm trying to listen in two directions at once.
Yeah.
Yes, that would be appropriate as long as the reporting restriction stayed in force in terms of the substance of the application, but that it was described in the terms that you just set out, sir.
There is nothing in the substance of the application yet, is there? I mean, it's still
not having gone through this process now, sir. No.
Yeah, Mr. Mansfield.
Yes, I'm sorry to make it slightly more difficult. Again, concerned with Harvey's particular interest here. And that is that if an interim order is made which doesn't really reveal what it's all about, other than it's to do with evidence that would have been heard today that might influence other proceedings, it's not going to be difficult for people to work out who is at the centre of this. And I would submit there's a risk of disproportionate prejudice being attached to somebody who is perfectly innocent. In other words, what is the problem that she is going to be, that she surrounds her in her giving evidence? And in fact, you've already, if I may say so, hit the nail on the head. There isn't any prejudice, in fact, in her giving evidence. Here, merely the fact that we've seen it many times.
Well, I think, to put it in a nutshell, the suggestion is that if she gives evidence and appears to be a very sound and credible witness, it'll be said that that will somehow prejudice the defendant, because the jury, all of whom will no doubt have been watching the live streaming of this inquiry, will say, oh, it's this lady again. We know how brilliant she was on the last occasion.
Methodist Church, yes.
Well, whatever it might be. I think that's, put it perhaps rather unkindly, but I think that's the nature of the complaint, isn't it? Well,
and of course that,
in my experience, that's a novel, but still.
On the witness at all. But if in fact it's all shrouded by the interim order, and obviously it would be, we'd be very concerned about that disproportionate prejudice to her for both proceedings, as it now turns out.
Well, maybe. I find it a bit difficult to see how it could prejudice her, but still, I wouldn't want to do that.
So may I add one further matter? That if any interim order is to be in place, that it would also cover, of course, publication of the application document itself and any documents that we supply as directed by you, sir. So the further publication of the application itself and the indictment.
And why the indictment, for heaven's sake?
Well, I'm not sure if I'm not sure if the indictment is a matter of public record yet. I'm acting on fairly limited instructions.
Hasn't there be a plea and directions hearing yet?
I presume so. I presume so. But not being CPS
If there's a trial
counsel,
on Monday, I hope there has. Is all I can say.
Sir, I appreciate the point, but I'm in a rather difficult position about what I'm being asked to do at this particular point.
Yeah. Well, given the fact that I've directed that the proceedings thus far not be reported until further order, I think it would be right to say that you should give copies of the relevant documents to the legal representatives of the BSRs in confidence, so that they are not distributed more widely until the application has been completed. At that point, we'll see where we are. All right, everybody? I won't say is everybody happy with that.
Mr.
Has
Chairman,
everybody got that?
can I take instructions?
Yes, please do.
Yes, Mr. Chairman. If the media, whoever they are going to make representations at the hearing on Friday, then obviously they need an application, the application as well, the formal application in writing.
They will.
As well, but they also need to be subject to that restriction pro tem.
They will.
And rather than it being the media, it should be limited to an identified person. And I don't know who that is at the moment. The Media Lawyers Group. I'm instructed that the Media Lawyers Group is a sufficiently identifiable person to be bound by the order,
Right.
to whom the application will be given.
Right. Well, then it seems to me then that the material should be served on the Media Lawyers Group on similar terms of confidence.
Yes.
Right?
I'm told so. The other thing is this, that obviously the reporting restriction which you've imposed would apply not just to the press, but also to any bloggers or people who
Of course.
use social media
Completely
to
general.
communicate. Yes. Yes.
Now, I've only concentrated on the position of the press, because the press are the nearest we got to the public for these purposes,
Yes.
who have a clear interest in the reporting of the proceedings.
Yes.
All right?
Yeah, that's right. But, the other thing is, I'm concerned as I stand here about the position of the RLRs as opposed to their clients. It may be difficult to police a reporting restriction once the community of BSRs knows about the substance of the application. It's not a point that Ms. Clark has made, and I'm not making it for her. I'm just trying to steer a neutral course. But there is, of course, a difficulty, because one does not want to make orders, you don't want to make orders in vain. No. So in the first instance, perhaps we should consider whether or not it goes beyond those in this room who have heard what's happened so far. Clearly, there is a process, and clearly people have to see what's been put in the application. One way round that, and I don't want to get in the way and spoil an already lengthy afternoon, is for Ms. Clark to reconfigure the application into a Part A and a Part B, Part A being those matters which she and her client, whoever that is, doesn't object to being seen by the wider community of core participants, and those parts which she would insist on being restricted to, and wants genuinely has a case for restricting to those who are in this room. And I anticipate that one of the difficulties is that not all BSRs are here, and certainly not all CPs are here. And I am concerned that we are creating a two-speed or three-speed group of core participants generally. I only raise that because I suppose it's my job to spoil things a bit, but these things need a bit more thought. Yeah. So perhaps in the first instance, rather than simply acceding to Mr. Friedman's application that we tell everyone who comes in what's been going on, which is unhelpful and too vague and dangerous, we take it a little bit more slowly. And the application document is reconfigured, it gets circulated to the RLRs. We can then perhaps have some written submissions as to whether that should go more widely to the clients and the core participants, and then take it from there at the Friday hearing.
Yeah. All right.
Mr. Chairman, I think that's probably unhelpful. I've rather got in the way, but I hope that assists in some way.
Mr. Steen's going to tell me why it's very helpful.
Well, Chair, the difficulty at the moment we have is not having sight of it. We don't know whether there's anything objectionable at all in the application that so far has been made by the police. So, Chair, you do have that. You would be able to look at it now and be able to come to a conclusion as to whether or not it cannot just be given to us immediately. So that's the first thing. Secondly, on what could be said when we regroup in public, there seems to us to be no harm in saying, generally, there are other proceedings that may take place next week, and there have been discussions about that. There does not need to be an in-depth examination of what has happened here. Thirdly, we would be assisted by a copy of the transcript of this afternoon's proceedings, so that we can reflect on what has been said so far. All of this has been gathering pace this afternoon. And finally, would you please order that if the CPS are to make an application, that they do so within a particular timescale? That may be by 1 o'clock tomorrow afternoon.
Well, I'd rather taken it that the existing application would stand as the CPS application, and I think it should, unless there's a good reason to the contrary.
Well, bear in mind that there is no representative here. We have, to an extent, considered a little lightly the position of counsel who is representing the police today, but there is, in fact, no representation from the CPS here today making any points on their behalf. We are anticipating the potential for an application. It will be a CPS application, not Ms. Clark. So the position we respectfully invite you, sir, to come to is that they should, if they are making the application, they may, after having consideration of what's been said today, and indeed perhaps the obvious difficulties with the nature of this application, that it's all based upon a fairly unlikely series of circumstances all coming together, they may reflect on it and, for good reason, not make the application. But if they are, can we not have it by 1 o'clock tomorrow?
Thursday. Yeah, you're only going to need it by 1 o'clock tomorrow.
I'm being
If
generous.
we're going to come back to it on Friday.
I was tempting to say 10 o'clock, but that's...
No, I think you wouldn't want to be unreasonable, would you?
Of course not.
No.
I try not to.
Yes, I think that makes good sense. So I shall, unless Mr. Millett's going to spoil it again.
No, I'm not going to spoil it at all. I just want to make one other point, which is those in this room understand, at least mostly, I think, that these other proceedings are those which do not involve Mrs. Wahhabi in any adverse way. I think it's important that whatever is said outside this room, it is made absolutely clear that Mrs. El-Wahhabi is a witness in other proceedings and is not involved in any
I should prefer
pejorative
not.
fashion.
I should prefer to say nothing about Mrs. Wahhabi, because I think that you're right. We don't want to embarrass her in any respect whatsoever. She's already suffered from having to come this afternoon to give evidence, to be told that it won't be today. And I think the less said about her specifically, the better.
Right.
I'm minded to tell the public simply that I had to deal with an application which was concerned the relationship between the inquiry and certain other proceedings,
Yes, that would
which had to be held in private.
That would be helpful.
Okay. Right. Well, then I hope someone's made a note of all these orders I'm making. But
My junior hasn't.
I'm going to say that if the CPS wishes to pursue this application, it must do so in writing by 1 o'clock tomorrow. And that application is to be served on the inquiry and on the legal representatives for all the BSR core participants. We'll word it a bit more elegantly than that in due course, but that's effectively what it will say. And there will be a little time for consideration of where we're going with this, given that now Mrs. Wahhabi won't be giving her evidence probably, I think, until the middle or the end of next week.
Mr. Chairman, point of mechanics, but while it's important, the application should be served on the inquiry, and we will provide it to the relevant RLRs.
Oh, there are practical reasons for that.
Yes, there are.
Yes, all right. We will distribute it to the RLR. Now, in relation to the transcript of this afternoon, if, as I hope, arrangements can be made to provide it to a limited class of people, I think that would be helpful. I'd like to see one. And I think the RLRs for the BSRs should also have access to it, but that it not be made available more widely. All right? Good. Thank you all very much for your help. At this stage, we could ask the public to come back in if they're still...
No, what I'd like to do is ask
Sorry,
you to
I'm
rise.
getting a message from the corner. Right. We've got to reset everything. Yeah.
Yeah.
Okay. Well, in that case, I'll rise now, and we'll resume this at 10 o'clock on Friday, and we shall, for avoidance of any doubt, be sitting in private when we resume, unless any orders made to the contrary. All right. Good. Thank you all very much.